So for those of you who have not met me before or seen me on screen, I'm Shauna Fleischbein with Castle Group. I'm the Senior Business Development Manager for the Greater Sarasota Tampa area. And if you're not familiar with Castle, we are a property management company, full service, and we specialize in full-time on-site management of large HOAs and condominiums. And today I am joined by Kirsten and Frank, who are going to be your experts of the day and are going to kind of run us through, elections, electronic voting. And, we've done electronic voting and topics before, but there's always the legal question. So Kirsten's going to be our legal expert today to kind of answer those questions as we go. Just really quick, we will be sending out before the end of the week. I will send out an email to anybody who registered with the link to this recording. So if you can't stay on for the whole thing or you want to share it with somebody, we will be recording it. And I'll also share the presentation as well and Kirsten Frank's contact information. So without further ado, I'm going to hand it on over and let you guys introduce yourselves.
Morning, everybody. My name is Frank Valdez. I work for GetQuorum. We're an electronic voting provider, full service in the state of Florida. So it's good to be with everybody. I appreciate the opportunity being provided by Castle and Shauna, and can't thank Kirsten enough for being alongside us as well. My background is in the property management industry prior to this role. I am state certified to teach e-voting courses to our licensed CAMs, have served on my own board of directors, showing you that I am a glutton for punishment, and I am now an unpaid advisor for my board as I've stepped off of the board. And again, prior to that, plenty of experience in the property management industry. So all in all, hoping to be your subject matter expert as it pertains to electronic voting. For the legal stuff, we'll turn it over to Kirsten.
Good morning, and I'm Kirsten Hensa. I am a partner and managing attorney for the West Coast office, which is located in Tampa. We are an exclusive community association law firm, which means that we represent only condominium, homeowners associations, and cooperatives as well. Our main office is in South Florida, but we have since grown and expanded, and so we do have other locations as well, including Palm Beach Gardens and in the Orlando area. And we're pretty much also a one-stop shop firm. So that means not only do we assist associations with their day-to-day operations, but we also assist with collections, foreclosures, and certainly dispute resolution. All right, so without further ado, let's jump into elections. So I just want to preface this by saying that, we do have a more detailed course that we do offer on elections for condominiums and HOAs. So the next few slides are only going to be snippets, sort of a warm-up about elections, just to kind of get us into the Q&A that will follow after Frank's presentation. We're going to give you, obviously, as much opportunity to ask questions as possible. So this is the intent of this particular webinar. All right, next slide. So we'll talk about condominium elections first. And I just want to quickly go over basically the notice requirements. So with condominium associations, elections are governed by statute and the Florida Administrative Code. Okay, so regardless of what your documents might say, you really need to follow the Chapter 718 of the Florida statute. And what the statute provides is basically two major notice requirements. So you're going to be sending out a first notice of your annual election meeting at least 60 days prior to the election. Okay, now if you are going to be instituting electronic voting, the Florida Administrative Code does provide that the notice has to basically include a statement that you will be instituting electronic voting. Okay, so those once you've mailed out this notice providing for the date, the time, and the location of your annual meeting, any owner member of your association who desires to run for the board needs to provide what is known as a notice of intent to run. And that has to be provided to the association no less than 40 days prior to your scheduled election. Now, I want to mention this. There is no statutory form of what a notice of intent to run needs to look like, right? So you can't require an owner to submit their intent to run at any particular form. You can certainly suggest it. You can even facilitate a copy of the form. And many management companies can prepare that for you. But really, an owner who wants to run for the board can literally write, on a piece of napkin, their intent to run, and you have to accept that. Okay, so there's no statutory form unless, of course, your documents provide otherwise. Now, in addition to submitting a notice of intent to run, sometimes you might be familiar, a candidate might want to include a little bio about themselves, right? So it's more of like a little resume, right? Wherein the owner will indicate basically, their qualifications and why they are suited to run and serve on the board. And so if the candidate provides you with this information sheet, then you would have to include that with the second notice of the annual meeting that we'll talk about in the next slide. Now, the candidate has a certain time frame within which to provide that information sheet, which is no less than 35 days prior to the election. And the information sheet has to be provided on an 8.5 by 11 piece of paper. Okay, so can't extend beyond that. Next slide. Now, once you've submitted the notice, once you've received the notices of intent to run and you've received the information sheet, the last notice that you need to submit for a condo election is your second notice. And that notice has to be provided at least 14 days prior to the election. Now, the notice, and including the 60-day notice, they can be mailed, they can be hand-delivered, and they can also be electronically transmitted, which means via email, provided, however, that owners have consented to receiving notices electronically. Okay, so if you don't have a written consent from an owner saying, yes, I consent to the association providing me with official notices by email, then email cannot serve as the official mechanism for providing notice to this particular owner. Okay, so make sure you have those written consents, which can be emailed as well. Now, your second notice of your annual election meeting is also going to include your election ballot, right? With all the names of the candidates listed in alphabetical order by surname. And you're also going to include your inner and outer envelope. So the inner envelope is the one where owners will insert their election ballot, and then that inner envelope will go into this, what is known as the outer envelope, and that outer envelope is what will be sent over to the association. The outer envelope has to include on the exterior of the envelope a line for the owner to identify their unit, as well as for them to sign the outer envelope. You will also include with your second notice the information sheet, if it was timely provided by the candidate, as well as the voting certificate, if in fact you are required to enforce voting certificates and do in fact enforce them. So a voting certificate will apply when a unit is owned either by multiple individuals, husband, wife, for example, or if the unit is owned by an entity. Right? So on that voting certificate, the owners will designate who is the individual that is authorized to vote for that particular unit. Okay. So if you enforce those voting certificates, you would include one in your second notice. Your second notice also has to be posted on condominium property, also at least 14 days prior to the meeting. All right, next slide. All right, In addition to your mailing of these notices, for those who currently fall under the website requirement, you have an obligation to post your notices of the annual meeting on your website, as well as post any document that is associated with the meeting, right? So your election ballot and any other document that you would have mailed out to the owners. The website requirement currently applies only to condominiums that have 150 units or more, but remember, okay, last year statute was changed, so effective January 1st of 2026, this threshold is going to go down. So the website requirement will apply to condominiums with 25 units or more, again, effective January 1st. Next slide. Okay. Now, on the date of your election, there is no membership quorum requirement, okay? And one hasn't existed for some time. However, the statute does say that at least 20% of the eligible voters have to cast a ballot in order for you to proceed with a valid election. All right, well, House Bill 913 that was recently signed by the governor and took effect July 1st adds a little wrinkle to this. The new legislation now does provide that if the annual meeting is conducted via a video conference, and we'll talk about video conference in a little bit more detail in a minute, then a quorum of the board must be physically present at the physical location where the unit owners can attend the annual meeting. So that means that if you're going to give owners the option to attend the annual meeting via Zoom, for example, then you need to have a quorum of the board physically present at the physical location of the annual meeting. What does that mean? Anybody's guess right now. So let's, I'm sure you guys will have questions and we'll address that during the Q&A. So let me just proceed with this. Now, aside from the election, so you don't need a membership quorum for the election. However, if you do have other agenda items on your annual meeting notice that you want to discuss at the annual meeting, excuse me, or you need, or you're presenting other issues to the owners for a vote, then you do need to have a quorum of the owners, okay? Proxies cannot be used for election. Remember, in order to vote for candidates, election candidates, they need to vote by ballot only. Next slide. Okay, some additional requirements that again took effect July 1st based on House Bill 913. The statute now also provides that if the bylaws do not provide the location at which the annual meeting has to be held, your annual meeting then must be held within 15 miles of your condominium or within the same county as the condominium property. So this used to say or provide for 45 miles from the condominium. Now the annual meeting has to be held within 15 miles. The statute now essentially clarifies that membership meetings, which includes your annual meeting, can be conducted in person or by video conference. And that term video conference is defined in the statute, which is at the bottom of the slide. And it basically means a real-time audio or video-based meeting between two or more people in different locations using video-enabled and audio-enabled devices. So essentially, your Zoom meeting will qualify as a video conference. Now, if an owner meeting is conducted via video conference, and that includes your annual meeting, then the statute imposes several requirements. Now, remember, you don't have to give owners the option to appear via Zoom, okay? That's a business decision, but if you do provide owners with this option, then you have to make sure you follow these additional requirements. Your notice of the meeting, okay, so your second notice of the annual meeting would need to include the hyperlink and the call-in conference number for the owners to attend virtually. Your notice also has to include a physical locations where owners can attend the meeting in person. And then lastly, you need to record all your Zoom meetings, and those recordings are now required to be maintained as part of the official records. Next slide. All right. So, not going to go into a lot of details, but just know that on the date of the annual election, or even preceding the election, you're going to have to verify outer envelopes. That's really the first step to your election. There's two ways that you can verify the outer envelopes, right? And that's before you even slice them open to get the ballot out. You can verify the outer envelopes on the date of the annual meeting, once you've called your annual meeting to order, or you can verify the outer envelopes in advance of your annual meeting if you want to save some time on the date of the annual meeting. If you do decide to verify outer envelopes in advance, you're going to have to do it by noticing a meeting of an impartial committee. So you're going to have to designate a committee that does not consist of any existing directors, officers, or any of the candidates, or any spouses of the candidates. So if you can get this committee together, you'd have to notice a meeting of this committee at least 48 hours prior to your annual meeting. And the sole agenda item of this meeting is to verify outer envelopes, the way you would typically do it at the annual meeting. The alternative is, once you call your annual meeting to order, then the first thing that you're going to undertake is get your committee out and then start verifying outer envelopes. Next slide. Okay, and then once you've verified all the outer envelopes, then you're going to go through the process of opening the envelopes. And remember, the polls close as soon as you slice through the outer envelope, the first outer envelope. So that is the moment where polls close. At any moment prior to that, while you're verifying outer envelopes, any owner can come in and drop off their election ballot. Okay, and I typically, if I'm requested by the board to attend a meeting and chair the meeting, I typically like to make that announcement ahead of time so that everybody knows that while we are verifying outer envelopes, any owner can still come in and drop off their envelope. Once you've sliced through the outer envelope, you're going to, of course, remove the inner envelope. And then once all inner envelopes are removed, you're going to slice through the inner envelope and then take out the election ballot and then count those ballots. And then elections are decided by a plurality of the votes cast. So it's not by a majority, it's simply the candidate gets elected based on plurality of votes. All right, next slide. All right, some additional new legislation that just took effect July 1st based on House Bill 913. Not going to talk about it in much detail, but just be aware that the statute now provides that unless the association has adopted electronic voting, which Frank's going to discuss in more detail, the association must designate an email address for receipt of electronically transmitted ballots. So an owner now has the option to electronically transmit a ballot, what the statute refers to an electronic ballot, to the email address designated by the association, provided the ballot basically complies with the requirements that we've outlined here in the slide. If the association receives this electronic ballot, they have to count it. So the electronic ballot has to include a space for the owner to type in his unit number, a space for the owner to type his or her first and last name, which basically functions as their signature. And then the ballot, the electronic ballot, has to include the disclosure on this next slide. Next slide, please. So the electronic ballot has to include the language in boldface, all caps, basically stating that waiving the secrecy of your ballot is your choice. You do not have to waive the secrecy of your ballot in order to vote. By transmitting your completed ballot through email to the association, you waive the secrecy of your completed ballot. If you do not wish to waive your secrecy but wish to participate in the vote that is the subject of the ballot, please attend the in-person meeting during which the matter will be voted on. So you're going to make sure your electronic ballot includes this. Now, unit owner must transmit his or her completed ballot to the email address designated by the association no later than the scheduled date and time of the meeting. And then there's a rebuttable presumption that the association has reviewed all folders associated with the email address designated by the association to receive the to receive the ballots. If a board member, officer, or agent of the association, including your property manager, provides a sworn affidavit attesting to such review. So essentially, obviously owners have the ability to vote by limited proxy. So it seems duplicative that this would be done during any vote other than the election, but it is what the statute currently provides. Unclear how this is gonna really roll out. So I think the big takeaway is that you'd want to make sure that you institute electronic voting, which Frank will talk about in more detail, to kind of avoid a lot of the confusion surrounding these electronic ballots. All right, next slide. All right, let's quickly move on to HOA election meetings, which are typically a little bit simpler. So essentially, the association is required to hold one meeting, which is your annual meeting each year. And at that meeting is when you're going to be holding your election. Next slide. The big takeaway with HOA elections is that election of directors for HOAs have to be conducted in accordance with the procedure set forth in the governing documents. So while condominium elections are more are heavily set on the statutory procedures, with HOAs, you have to follow the procedure that's set forth in your bylaws. Now, you might, it's very possible you may have adopted different procedures over the years by rule or policy. You really need to amend your documents and incorporate those new election procedures into your bylaws if you really want to follow them. Otherwise, this really subjects your election to a potential successful challenge. Next slide. The notices of your election meeting essentially would have to be provided in accordance with whatever procedure is set forth in your bylaws. And if you don't have anything specifically addressing notices of election meetings, then you would just provide notice in accordance with your notice requirements, which would typically be 14 days prior to the meeting. And as with condominium elections, you will either mail, hand deliver, or you can email your notices to the membership, provided, of course, you've received written consent from the owner to receive notices electronically. Next slide. With HOAs, unlike with condominiums, there is a nomination process from the floor. Now, the statute does provide that if the election process set forth in your governing documents allows candidates to be nominated in advance of the meeting, then the association is not required to take nominations from the floor. Okay, if you don't have such a procedure in your bylaws, then you're absolutely required to take nominations from the floor on the date of your annual election meeting. Next slide. Also with HOAs, there is a quorum requirement for your annual election meeting, and so you have to establish quorum before you can proceed with your election and the rest of your meeting. Now, unless your bylaws provide for a lower number, 30% of the total voting interest will constitute a quorum for your HOA. Okay, and if you do not meet the quorum requirement for your HOA annual meeting, then of course the existing board will just roll over. Next slide. On the date of the election, owners have the right to vote in person or by proxy, unless of course your governing documents provide otherwise. And then if your documents do provide for voting by secret ballot, for those who are not in attendance, then just be aware that the statute does require those secret ballots to be returned in the manner that is currently provided for condominiums. So there has to be an inner envelope and as well as an outer envelope. Okay. And then the ballots and proxies are tabulated on the date of the annual meeting. Next slide. I think that's it. All right, Frank.
You made it, Kirsten.
Right.
Good job. You got to the finish line. Thank you.
You know what? Sorry, Frank, before you get in, there was, let me see, a couple of questions I guess that came in just a few minutes ago. So we'll throw those at Kirsten real quick. Somebody wanted to know what happens if an owner sends in more than one electronic vote. I don't know, maybe this will fall into Frank's presentation. And then the other question was, can electronic ballots be used for agenda items beyond the election of directors? So those are out there, whoever wants to, unless you're going to cover it.
I will let Frank discuss the electronic voting, but with election ballots, once a vote is submitted, once an election ballot is submitted, it can't be rescinded.
Right.
Okay.
Good.
I'll let Frank handle the
That's exactly what I was going to say. So good. We get that question. It's probably one of the more frequent questions that we get. And again, it's good to be with everybody. So we'll dive into some electronic voting information here. And keep the questions coming, right? The Q&A chat. We're going to go right back to it as soon as I finish, my presentation. But I get that presentation or that question probably more than anything else in our demos. And it's usually first vote in is the one that counts for something like a secret ballot. Very important to understand that. In the case of a limited proxy where we're helping an association with something like a bylaw amendment, material alteration votes, funding of reserves, there's so many votes that could potentially end up in a limited proxy. Those are rescindable, those are revocable votes for that owner. And so you could potentially revoke that vote and resubmit a vote to that matter. But as it pertains to Kirsten's point, to an annual meeting, right, or election of directors, it's usually first vote in as the one that counts for that unit, and it is unrevocable at that point. So we're on the same page for that. And I know there was another question there. If an owner sends in more than one electronic vote. So let's dive into it since it's there in the chat. We'll take a little pause. And again, I've got some good information here that might cover some of these topics. If more than one vote is cast for one unit, our platform, specifically electronic voting in general, should not allow for more than one electronic vote to be cast for the same unit. While there can be more than one owner signed up for electronic voting, the programming on the back end should restrict for only one vote and allow for only one vote per unit. And so you should not be receiving more than one electronic vote submitted. However, there are cases where there might be an electronic vote submitted and then somehow that owner got their hands on a paper vote, right, or paper ballot, and that has been cast. And then we're going to probably provide you guidance to consult with your legal counsel because there's a few avenues there. Most of the times it's first vote in that counts. And in some cases, the election monitors and the DBPR is referring back to the electronic consent, stating that the owner consented to electronic voting, so the paper vote should not be counted. Good practice for every single association on the call today. Try to avoid that. Certainly put in some parameters, some guardrails. And have some best practices in not sending out paper ballots to owners that opted into electronic voting and electronic notices. There's no reason why you should be sending out mass paper ballots to those owners because you will receive duplicate ballots. So try to avoid that from the front end. But again, consult kind of legal specific to your association docs and your meeting procedures to know what to do in the event you get two votes, right?
Yeah. Extra expense too. If you're sending out paper ballots to people who are signed up for electronic voting, you're obviously, paying the extra expense for that as well.
100%. Yeah. 100%.
Yeah. And then we got that. Okay. What happens if owner sends in more than one electronic vote? Okay. So we already talked about that. Use the can electronic ballots be used for, oh wait, sorry. I was in the answered instead. Can a vote, is electronic vote submitted? I just heard that it cannot be rescinded. Can the owner change their vote? This is for an HOA community.
Right. So elections, no. Right. Whether it's HOA or condos, that's a no. Again, you can change your vote for something like an amendment, right? Those are revocable votes up until the polls closing. So I just want to be very clear. I get that question a lot. And if we're helping a community provide an update to an amendment and vote on that, or again, vote on a material alteration vote in a condominium, those can be revoked if the polls have not closed, and you can change your mind on those specific answers. So as far as elections, no. Other votes, usually yes. I see a question here. Are there statistics that show that electronic voting lends itself to a higher number of participants versus paper ballots? 100%. So what we've seen across 3,000 communities that we provide electronic voting for, all throughout, not just Florida, but the US, is a 70% participation rate year one. That's what you can expect in your communities. 80% year two. And again, that's a very, very specific benchmark that we've seen across the board. Very high participation rates, which will help you kind of alleviate and get some things done that you haven't gotten in the past. So let's dive into a few things here. Some of it will be repetitive. I know Kirsten might have mentioned a few things, so we'll skip over it, but we'll dive right in. Let's go for it. Go, Shauna, next slide. All right, and we'll talk about some of the House bills. So, segue from that last question, does electronic voting help increase participation? It does. Here's the crazy part. Since 2015, the statutes have allowed for electronic voting in the HOA and the condominium space. So our 718s, 19s, and 20s actually are co-ops as well. What we did was kind of parking lot it for a while, right? Floridians were really busy people. And then the pandemic came in and everyone was scrambling, hoping to adopt electronic voting. Good news, we've got north of 32% of the communities in the state of Florida, and there's a big number of associations. So I know 32% doesn't sound very high, but there's something like 7,000 associations in the state of Florida, if not more, right? So we've got a long way to go, but certainly have come a long way in the last 10 years. So again, if you're on the call today and you're listening and whether you're HOA, condo, or even a co-op, you are allowed to adopt a resolution to allow electronic voting. We'll dive into that in just a moment. And again, on average, you've got 20% participation rates when you're strictly using paper. What we see by the second year is 80%. This includes a ton of case studies of 55 and better communities for those on the call today. So we've got proof that we've assisted communities like Century Village over in Deerfield Beach in the east coast of Florida, and on the west coast, there's just quite a few, and it's been adopted at a very high rate. So it's not an age thing, or it's not an electronic thing. These days, most folks have an email and have a phone, and they are certainly leveraging this technology. Next slide. All right. So again, here are your statutes, right, that provide the language as to what you should be following. Here with the responsibilities of the board of directors and the electronic voting provider. So if you're 718s on the call today, there's your 718.128 or 719.129 and 720.317 for our HOAs. Here's a few of the bullet points from the statute. You're welcome to Google this right on your own. But for the most part, you do want to involve your association attorney as well. And it starts with making sure that the board of directors passes a resolution to allow electronic voting to be used. All right. So resolution must be passed by the board of directors in a noticed meeting. That has now changed to a 48-hour notice for condominiums. It used to be a 14-day notice, and it is a 14-day notice still, as far as we are aware of for our HOAs. So you've got to provide for a 14-day notice, letting owners know that the association will be allowing electronic voting to be used. And again, that a resolution will be voted on by the board of directors. Consult your legal counsel for a resolution template that you should be using. In terms of what happens after that, owners do have to opt in to electronic voting, right? So they do have to opt into electronic voting. If they do not opt in or consent to electronic voting, they are opted out. So as of today, from my understanding, we cannot opt in any owners without their consent. They've got to consent and opt into electronic voting and even electronic notices if that's the way you want to move in your community. Good news for the owners that perhaps don't have an email address or are not ready to vote electronically. They do not have to take any action. They will continue to receive paper-based notices out there. The benefit, or the biggest benefit of electronic voting, is that unit owners that vote electronically count as being in attendance for the purposes of determining quorum. They do not have to show up to the meeting. They do not have to physically be there at the meeting or virtually. By way of just casting that electronic vote, those owners are counted towards the quorum and their vote counts. So you can be, especially these days, in a cruise ship or in the middle of the sky on an airplane on the Wi-Fi and counting or casting your electronic vote, and you will receive an electronic receipt. So again, board resolution, best practices there. Make sure that you're all on the same page, management and association and legal. There's a few kind of best practices here. I think we're going to circle back around to these at the end as well, but definitely make sure that you're establishing procedures for owners to opt in to electronic voting and opt out. That should be part of your resolution. I think the biggest fallout that we see there is that when we look through those resolutions, there isn't a reasonable time frame for owners to opt in or out. So it's kind of open-ended. And then we've got owners kind of 24 hours before the annual meeting trying to opt into electronic voting. That's very challenging for us as an electronic voting provider. It should be something like 30 days before your annual meeting. You know, there should be a pause and opt in of electronic voting and opt out. I think the statute right now is at least 14 days. But again, you know, you're welcome to space that out a bit more to make sure that you're not challenged in having owners opt in or out. We'll go to the next slide, please. All right. And again, 2015, so it's been around now for 10 years. We're coming on a decade. 48-hour notice resolution for our condos, 14 days still for our 720s. Your voting members have to consent. That consent can come by two ways: a written consent on paper, so paper consent to opting into electronic voting. And that consent form, again, should be provided by legal. We certainly, as an electronic voting provider, do have some templates that we share out there for you to review with your legal team. But there must be a consent on file. It is not just a checkbox, and we think we got someone to opt into electronic voting. There has to be an actual consent. Good news, the consent does not have to be specifically written or on paper. As of this year, there can be an electronic consent on file as well, right? So an electronic consent signed electronically by the specific owner, the authenticated owner, that counts. That's just as valid as a paper consent on file. Please keep those records. I can't emphasize that enough. That's an official record of the association. Owners will forget. I've been in Lakewood Ranch. I've been in a homeowner association meeting, and owners have forgotten about a week and a half after opting into electronic voting. They had no idea if they ever opted into electronic voting. We were obviously able to refer back to the electronic files and show them and reflect that they opted into electronic voting. But keep these records if you're running this thing by hand, if you're doing it by paper. Keep those records. If you are providing electronic consent forms and getting those back, make sure you've got those copies. They do not have to opt in again every year. So owners stay opted in perpetuity. And that's a big plus for you, so long as you have those records, right? If you don't have the records, you might have to reset the process. So next slide. All right, let's get into some of the House Bill 913 and how it affects electronic voting. So it certainly did affect us. And again, some of this stuff's repetitive, so I apologize in advance, bear with me here, but I'll make sure that it speaks more so to the electronic voting world and environment. 14-day requirement for board meeting notice to adopt electronic voting or vote on a resolution to allow electronic voting. That was deleted. What that told us, it's a normal regular meeting notice now. It should be something like 48 hours for a board meeting to adopt that resolution. Again, that is a board vote only. That's not a membership vote to allow electronic voting to be used. Here's another one. If 25% of the unit owners petition the board to adopt electronic voting within 180 days of the last annual meeting, the board has to hold a meeting within 21 days and adopt electronic voting. So there's definitely a wrinkle there in the statute where before it was fully up to the board, right? They kind of controlled and possessed whether that association used electronic voting. And clearly, I think what we're seeing here by way of these this House bill is that they're putting the power back in the voters and the owners and saying if they really want to move forward with electronic voting in the community, then obviously here is the avenue or the vehicle to allow them to do that. So again, some of these things have been discussed already. Official records include these electronic records, right? Including all of the electronic voting records as well, video conferences, affidavits, that sort of thing. Those should be kept. Whatever electronic voting provider you are using, please make sure they are providing these electronic voting records. Generally speaking, they're cloud-based, so management has access to these records well beyond, and they should be available for official inspection, especially by someone like an election monitor, right, that wanted to inspect these records, or an owner that filed a records request. Again, some of the stuff we spoke over, but video conference, right, was a very loosely used in the past. We're just getting into the nitty-gritty of Zoom or other video conference platforms. Some boards decided to record the meetings. Some boards decided not to record meetings. And what we're seeing now, obviously, is that if that is being used, it must be recorded, it must be kept and shared. Again, we're seeing the move for clear transparency, right, in these communities. I think that most of these updates speak to usually the complaints or the challenges that they were receiving at the state level. If, again, unit owner membership meetings are held electronically, you've got to make sure that owners have a vote electronically. Here was a new one too. If electronic voting was used by an owner, the board can't take it away next year and say, hey, you can't vote electronically the following year. You've got to afford them an option to vote electronically moving forward. We saw some tricky business with some boards that allowed electronic voting and then kind of took it away when they saw the massive participation rates, scared them a little bit, I guess, moving forward. So again, some of those things they've cleaned up. Next slide, please. All right. So here's, in summary, some of the other items. Annual membership meeting held electronically, quorum of the board of directors. I know Kirsten mentioned that. Very different that they have to be physically present. I know that there was very loose options in that. You can, log in by phone or call in, and now they've got to be physically present at the location, at least a quorum of them. And then again, if the association has not adopted electronic voting, so it certainly behooves you as an association to have an electronic voting provider, which will organize this, clean this process up, and make sure that they manage the process for you, which is what we do here. But if you don't have that, guess what? Owners are still going to have the opportunity to cast an electronic vote, basically. A very challenging one, the way it's rolled out. In speaking with some of the attorneys at KBR, including Kirsten, it's very challenging to know who's going to control this general email address, right? How will these be scrutinized? The election monitors, I'm sure, are reading number 7 there in the state of Florida, thinking, wow, that could be very challenging for us as an election monitor to make sure that all of these votes have been submitted by the official owner, because there isn't an authentication method that's been used here for these owners. It's just kind of a name on a piece of paper or electronically speaking. And then we kind of have to hope that that was the owner that submitted it. So there is an electronic or an email address that has to be set up by the 718s now, or condos, and they have to allow, again, an owner wishing to send in a ballot electronically to send it in. This only applies to associations that are not allowing electronic voting to be used, at least through an electronic voting provider. These condominiums, if they do have an e-voting provider on hand, owners should be leveraging the obviously the process being afforded by the e-voting provider out there. All right. Remember, this is a summary only. All right. Here's some best practices. Let's move forward. Awesome. Here's some best practices. And again, I know we went through a lot of stuff. You've got some subject matter experts here on the call today. So we'll certainly be available beyond, the information we've given you to dive a little bit deeper into your specific community cases. But consult and involve your legal counsel in the process and management. I can't emphasize that enough. You don't want to surprise anybody the day of the annual meeting or the elections and let your legal team know, hey, we've got electronic voting. We adopted it 6 months ago, and we're going to have electronic ballots today. That is not the time to let your attorney know that you've got e-voting. So make sure that they're certainly part of the process and understanding that the association has allowed official electronic voting to be used. Make sure that you're reviewing and accounting for existing bylaws. I know Kirsten mentioned that earlier today, especially our HOAs. Make sure that you are still following a lot of those meeting procedures that have been set forth. Please over-communicate with owners. I can't emphasize that one enough as well. Make sure that owners understand the difference and the changes in meeting procedures. If you're allowing electronic voting to be used and you've contracted with an electronic voting provider, make sure the owners know this. Make sure they understand when electronic voting closes. Make sure they understand that they have an option. If they don't want to show up at the meeting to cast an electronic ballot, make sure that information is very crystal clear going back to your first notice or even beyond that. Make sure that you choose a suitable platform. All right. So here's another do. Choose a suitable platform for your specific community. If you've got nominations from the floor and voting the day of, you've got to make sure that the electronic voting provider that you are contracting has the suitable platform to allow for nominations from the floor, right? That certainly takes a little bit more technology, I can tell you, than a normal advanced ballot. Make sure meeting format is organized. Make sure you hold a dress rehearsal. And I can speak to us on the call today, right? We were here yesterday, basically. I think a little bit later in the day than now, almost 24 hours ago, making sure everything was working, walking through some of the ins and outs of today's meeting. No different than what your election or annual meeting should be, right? Make sure the technology is working, that you are on the same page, that you and attorney and management and electronic voting provider certainly have everything buttoned up. Technical support, if you need some of that for your virtual meeting, make sure you've got that working, right? The Wi-Fi, some redundancy. And again, help everyone be prepared. I know for management, this is a lot, right? But making sure the board members, owners, and legal are kind of all aligned before that meeting, whether it's an annual meeting, an election meeting, or whether it's a special meeting for an amendment in the community. I can tell you that our go-to and the folks that we're usually attached at the hip with is association management to make sure that all of this gets rolled out and certainly executed at a very high level. So I think that might be it, but next slide here, all right, we've got a little surprise for you guys, a little present here. Here's a meeting notice deadlines calculator. For those on the call today, if you scan that QR code and you don't have to, it actually provides you a freebie there. So Get Quorum has put together a meeting notice deadlines calculator. It's easy. You put in the date of your annual meeting and it counts the notice requirement dates backwards for you. All right, so you've got a little tool there to give you some help in knowing when your notices are due. Generally speaking, if there's something off, you can certainly let us know. And I think on my part, I'll leave it there.
Yeah, we've got a few questions that came in. Are there any state approved electronic voting platforms, Frank?
No, there are not as of yet. So what the state did in 2015 is they put forth those electronic voting statutes that I referenced earlier, and they put forth some legal requirements from these platforms, right? They have to have a method to authenticate an owner. There's a few kind of bullet points there that these platforms have to provide. They have to maintain the secrecy of a ballot if it is a secret ballot all the way through. So as you read through those things, the platforms that are in use have to be compliant. We are not aware of the DBPR or the state having a department right now, and they're quite busy to provide official certifications to these electronic voting providers. What we've done to go the extra level, and I do recommend this to any association, make sure that your legal counsel has reviewed the platform that you're considering, vetted it. I know we have a legal opinion, for example, on our end from a very well-respected, law firm here in Florida, and they've reviewed the platform. So again, no different than what your attorney should be doing if you're considering any electronic voting platform for the association. Make sure that they're aware of who you're going to use and that they feel confident in that it is abiding to all the Florida statutes. But there isn't like a certification officially as of today.
Okay. It's a good one. What happens if an owner votes electronically and then sells their unit before the meeting is held?
That's an excellent one. That vote should not count. Kirsten, correct me if I'm wrong, but that vote should not count. And so that vote usually is invalid. What we do as an electronic voting provider is we've got some integrations in these back-end systems of rosters so that when management updates on their end the change of ownership, the electronic voting platform immediately receives that change and tosses out, for example, any invalid votes, right? So those are some of the processes we've put in place. But generally speaking, what you want to do as a best practice is no matter who you're using, make sure management gives an updated roster of ownership, perhaps, a day or two before that official meeting is taking place, and any owners that have sold their unit and that have casted a vote, obviously at that point that can be addressed prior to the meeting. Not if it has to be at the meeting, it can be done, but hopefully prior to the meeting, there's a high level of communication between management and electronic voting platform.
And I know you have a good answer for this, Frank. Are there any white papers? I don't know if there's white papers officially, but I know you have information on what show that show a positive ROI with cost savings with electronic voting versus the cost of postage, envelopes, cam time, etc.
Absolutely. So I would encourage everybody to look at your printing and postage budget line item in your certainly in your budget, right? Whether you're HOA or condo. When you take that line item and usually reduce it by about 70%, those are the savings that you're going to see if you adopt electronic voting in your community. The ROI is massive. Electronic voting costs costs a few dollars per door, generally speaking. So for about the cost of one mailer, you've got electronic voting for 12 months, for a year. The ROI is huge. I think that's why there's been such a wide adoption in a very short period of time.
Excellent. You guys must have done a great job because those were all the questions. And just for everybody out there, like I said, I'm going to email out a copy of the recording or link to the recording as well as this presentation with both Kirsten and Frank's information here that they've gone through. But if there's any interest, both Kirsten and Frank have courses that go deeper into their portions of what they covered today. I think they're like about an hour, right, for each of them. And so we could always, if there's any interest, reply to my email I send you. And, if we see a lot of people saying that they're interested, then we can definitely coordinate with them to, provide some additional, information in their realms there. And I think they're for credits for the CAMs or no one, are they both for credits for CAMs? Yeah. And
Yes.
this, okay, perfect. And then this presentation, because I'm sure somebody's going to end up probably asking, is not for any credits for either CAMs or board members. Board members, I hate to tell you, but Kirsten can back me up here. We still don't know what's going to be required, like what official courses will count towards the credits the DVPR is saying that you need. Let's see. Excellent presentation. Thank you for sharing your knowledge and thank you. So yeah, I think we got all the questions. I'm going to send out Kirsten and Frank's information as well. It's on the screen now. So if you think of anything else afterwards or you want to pick their brains further, I'm sure they would be happy to do so. And yeah, we appreciate you guys. Thank you both for being here. This was excellent. We appreciate your time. And I hope everybody has a great rest of your week.
Same here. Thank you for the opportunity. Good to be with you guys today and be aside some seasoned experts here in the industry. So appreciate you guys.
Yeah, same
Thank
here.
you all. Thank you.
All right, guys. Well, have a great afternoon. Take care. Bye.
Bye-bye.